Chapter 11, tort of negligence. We talked about negligence very briefly in Chapter 10, where I explained that it was an act of carelessness. Not an intentional act, but something where we just, by mistake, depart from the standards of society. If you're driving a car and you happen to hit the other car, it's not acceptable to normally do that, but normally it's seen as being you acting negligently, not you acting recklessly or intentionally, that you intended to actually drive into the car in front of you. That's the basic example. You'll see again, they give, as always in this book, and they're wonderful examples that you can follow from, but they do give you the business law example in practice on page 243. Please read it over. It helps you to understand, relate to these concepts that we're going to be discussing in this chapter. So what is the law of negligence? They give an example. A negligence action can be brought by somebody who has been injured by dangerous driving of a delivery truck driver, who has suffered loss by relying on poor advice given by an accountant, architect, engineer, or lawyer. And they also give the example of furniture that's been damaged in transit by a moving company. Those are all examples of a negligent act that might be the subject of a lawsuit. Ultimately, it's a failure to show reasonable care. The care that a reasonable person would exhibit in a similar situation. And we discussed the reasonable person a long time ago when we were talking about how to interpret various contractual provisions. Same thing exists. What is the reasonable person? There is no one reasonable person. We try to attribute, we try to say that society would normally expect for anybody to act in this particular fashion. That is the reasonable person. If we go on to page 245, we discuss establishing a negligence action. And we get specifically into the elements of this notion of negligence. The first thing we discuss, and actually they do a really good job starting on the bottom of page 245 to show what these elements are. 1, 2, 3, and 4. Okay? First one, number 1. Does the defendant owe the plaintiff what's called a duty of care, defined as the responsibility owed to avoid carelessness that causes harms to others? To give you a sense of what the duty of care is all about, go back to page 244. We go back to this important case from Canadian legal history, the Donahue v. Stevenson case, 1932. Before large-scale production, most goods were sold directly from producer to consumer, and by the 20th century there was multiple stages within the chain. And the factual background here is a customer bought some ice cream and an opaque, a dark-colored bottle of ginger beer for their friend. Some of the ginger beer was poured over the ice cream and some was drunk by Donahue. When the remainder of the beer was being poured into a tumbler, a decomposed snail was discovered in the contents. Donahue became ill and subsequently sued the manufacturer for damages based on negligence. At this time, the legal question is the extent of the manufacturer's duty of care. Back then, it was severely limited. A manufacturer was only responsible to those with whom it had a contractual arrangement. Most consumer victims were prevented by this limited responsibility from being able to recover damages. There was almost certainly a retailer in the transaction, and there was no direct manufacturer, there was no direct contractual relationship, therefore, between a manufacturer and a consumer. Okay? If you're making a bottle of soda, as the manufacturer, are you selling it directly to the person who wants to buy it? The answer is no. There's a retailer. So normally, does Sobeys directly or the Superstore directly manufacture its own Coke products or Pepsi products? The answer is no. They go to Coke, they go to Pepsi, they go to another company, they purchase them off, and they have an agreement to sell those products. The resolution here, Lord Atkin for the majority wrote the following classic statement when discussing how to determine to whom a duty of care is owed in negligence. And I'm just reading it straight from the book. The rule that you are to love your neighbor becomes in law. You must not injure your neighbor, and the lawyer's question, who is your neighbor, receives a restricted reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. Who then, in law, is my neighbor? And the answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called into question. In other words, when we're dealing with this manufacturer, the manufacturer owed a duty of care to people who reasonably could have used their product, whether or not they directly purchased the product or whether they were given the product. Was there a duty of care to ensure, in this particular case, that a snail didn't end up in a bottle of ginger beer? The answer is what, guys? You should be saying yes. The Supreme Court of Canada since 1932 has continued to refine what the definition of duty of care involves. And we'll see toward the top, page 246, that a court must first ask the case involves a novel situation or not. If the case is comparable to something that's already decided in which a duty of care was recognized, then stage 1, described immediately below, can be skipped, and the plaintiff can proceed on to stage 2, which is also defined below. If the case is novel, if it's almost unheard of, this type of scenario, then the court is required to assess the issue of duty of care. And this is where step 1 comes in. In the relationship between a plaintiff and a defendant, is there a prima facie duty of care? Prima facie is on first appearances. Is it a facial duty of care? If you look at it, does it seem as if there is, just by plain sight, that there is a duty of care? And they get into this issue first of reasonable foreseeability. That the harm that occurred was a reasonably foreseeable consequence of the defendant's act, and reasonable foreseeability considers whether the defendant should objectively have anticipated that his or her act or omission would cause the plaintiff harm. Now, it's not just a matter of reasonable foreseeability. In order to determine the duty of care, it's reasonable foreseeability plus proximity. There has to be sufficient proximity between the parties so that it wouldn't be unjust or unfair to impose that duty. And it depends upon the specific circumstances combined with the legitimate interests of the plaintiff. And there are some good examples that you'll see later on the bottom of page 246, top of page 247. Yes, there may be a reasonable foreseeability, but the proximity. Now, say that we have a tragic event that occurs 2,000 miles away from us that may involve somebody who we care deeply for. And it's because of an act of negligence on the part of another. And because of that negligent act, I or you, 2,000 miles away from the incident, have an emotional reaction to it. And it deeply affects us. Deeply affects us. Can the person 2,000 miles away who caused the damages, the tortfeasor, can they also be held liable for whatever emotional harm that I suffered 2,000 miles away? The answer is no. Was there a reasonable foreseeability? Perhaps there was reasonable foreseeability. But the issue of proximity, distance matters here. I am not right there. I am not seeing it occur. I'm hearing about something third hand. Even if I see a video of it in this day of cell phones with video cameras, can I necessarily say that I, in particular, am owed a duty of care? Normally, the answer would be no. Go to stage 2. If this is a common situation that has already been assessed, evaluated by the courts before, then we get to stage 2 and we just go straight to stage 2. Are there residual policy considerations outside the relationship of the parties that may in some way negate, cancel out the imposition of a duty of care? And again, that's rather novel, but you have to consider that, and you can read about that further. Because normally, when we look at it, we look at stage 1, reasonable foreseeability and proximity. There may be some type of special relationship that may in some way negate the duty of care, but oftentimes there's not. After we assess the duty of care, and we assess the two subparts of duty of care, reasonable foreseeability and proximity, then we ask ourselves, page 247, did the defendant breach the standard of care? We have duty of care and we have standard of care. And the standard of care in negligence law is what? The reasonable person standard. The standard used, as you'll see defined, to judge whether a person's conduct in a particular situation is negligence. All right, and you have to assess the reasonable person by who they might be. We're not saying that there are differences, but if we take this into a professional context like we did in Chapter 10, and we say this is a lawyer or a doctor, an accountant, somebody with specialized training, then we don't look at them as if they're the reasonable ordinary person. We look upon it as whether or not they're the reasonable professional in their field. They're held, as I said in Chapter 10, to a higher standard. And how do you assess that in any given case? It's on a case-by-case basis. So, let's go back. Duty of care involving reasonable foreseeability plus proximity. And then, once that's assessed, then you deal with standard of care, the reasonable person standard. And then we move on to number 3, where we deal with the issue of causation. Causation, defined at the bottom, the relationship that exists between the defendant's conduct and the plaintiff's loss or injury. And that is the basis for causation, is this notion of, would this injury have occurred but for? Those two important words when it comes down to this third element, but for the defendant's conduct. So, duty of care with its subparts, standard of care with the reasonable person. Causation, but for the defendant's actions, would this person have suffered this injury? Would this plaintiff have suffered this injury? And you'll see a couple of good examples, especially on page 248 with the Hankey case. Finally, fourth element of negligence. Was the injury suffered by the plaintiff too remote? We deal with the issue of remoteness of damage, very similar to what I said before when we were talking about duty of care. The absence of a sufficiently close relationship between the defendant's actions and the plaintiff's injuries. So, is it too remote? Listen, guys, I'm originally from Orlando, Florida. And in approximately June of this year, Orlando was the victim of a horrible tragedy at a nightclub called Pulse. And Pulse happened to be about a 2-minute drive from where I used to own a home. And even to this very day, today, realizing that 2 of the survivors of Pulse are going to be speaking on television tonight, there was an emotional reaction from me. It hit hard, not because I knew any of the people there directly, but for whatever reason, it caused within me an emotional reaction. Can the person who perpetrated this, who's now deceased, the guy who actually shot up that nightclub, killed 49 people, injured scores of others, can that person or his family be sued by me? Here in Nova Scotia, 2,000 miles away, without having any real connection to any of the victims. I didn't know any of them. And the answer would be, well, that person or that person's family who I would try to sue, that they would say there's remoteness here. Yes, we understand perhaps that Derek Brett was affected emotionally by what happened, but could we have necessarily sensed that Derek Brett would have been damaged as a result of what the gunman did at Pulse? And the answer, I think most courts would say, is no, it's too remote. Derek Brett should not be able to maintain such a lawsuit. So again, let's jump back. All right, 4 elements here. Duty of care. Bottom of page 245, with its 2 subparts, reasonable foreseeability and proximity. Part 2, is there a breach of standard of care? Reasonable person test. 3, did the defendant's acts cause what happened here? Or, otherwise stated, but for the defendant's actions would the plaintiff have suffered harm? 4, the issue of remoteness, page 249. Those are the issues within any negligence test. Now, page 250 touches on something called the thin skull rule, something that in my career I've called the eggshell skull rule, meaning effectively you take a victim as they are. Even though the tortfeasor, the defendant, the person who had caused the injury, the damages, may not have known that somebody was particularly fragile, had a particular condition, notwithstanding, you were still responsible for the full measure of additional damages for somebody who may have a thin skull. And we're not just talking about thin skulls. We're talking about a range of issues that somebody may be suffering from, whether it be mental or whether it be physical. It's not just limited to whether or not my skull may be a bit easier to crack than other people's skulls. And you'll see the definition there toward the top of page 250. Please also note, if you could, that tort law itself, page 251, is reluctant, is hesitant to actually permit recovery for what we call pure economic losses. That's defined there for you. Financial loss that results from a negligent act where there has been no accompanying property or personal injury damage to the person claiming the loss. If it's purely about economic loss and not about personal harm, property damage, then tort law itself is not going to, just by virtue of something you're claiming for pure economic loss, is not going to allow for somebody to collect that way. And they do a really good job on that paragraph where pure economic loss is located in boldface type of defining it and helping you to understand it. Please review it carefully. Continuing on, defenses to a negligence action. We talked about bases for finding negligence. Now we're going to talk about what the tortfeasor, what the defendant can do in his or her or its own defense. And we come up with defenses. Now we've seen, and we've already mentioned one before, and you'll see it coming up again on the bottom of page 251, contributory negligence. Contributory negligence, where the plaintiff is responsible for at least a measure of their own damages, that it's not all the tortfeasor, the defendant's fault. That's one particular argument that can be made, that the plaintiff contributed to the measure of damages. Maybe the defendant is partially responsible, but they're not fully responsible for all damages that were suffered by the plaintiff. The second one, by the way, please read over the Kralik case. It's another key case in Canadian law. It's only from 2008, so it's relatively new. But you can get a sense of what contributory negligence is all about right within the Kralik case. Please read it over. It's a great example. Voluntary assumption of risk. How many people here like to bungee cord jump? When you bungee cord jump, even though normally you sign off on what's called a waiver, say there wasn't a waiver. You're assuming a particular risk. You're doing something, whether it's skydiving or bungee cord jumping, or something that you would identify as involving a traditional risk. You're assuming that risk. And that assumption of a particular risk, because you already know it's dangerous, that it's fraught with peril. That assumption of risk is something that a defendant can assert in trying to reduce or to nullify, to cancel out any type of damages. You'll see it actually defined on the bottom of page 252. No liability exists as the plaintiff agreed to accept the risk that was inherent, that was a core part of the activity. Again, this is something where you think, okay, normally people don't actually do this. If I go right now and I hire an outfitter to bring me into Tibet or Nepal so that I can climb Mount Everest, and say I don't make it up the full length of Mount Everest, in fact I freeze myself to death within the first few thousand feet, is the outfitter responsible for the fact that I froze? If they took all reasonable care to ensure that I would be able to, traditionally to make sure that I would be given the opportunity to do what I found to be inherently risky. The outfitter probably would not be held responsible. I would understand that climbing Mount Everest is an extraordinary thing to do, and that trying to do it there is bound to be some type of risk. If you end up going on one of the first private space voyage flights, is there an assumption of risk involved with that? The argument is perhaps, yeah. Even though there may be a duty of care, there may be a standard of care, there may be causation, but again, are you assuming a particular risk by actually taking a flight into outer space? Assumption of risk. The Crocker case on page 253 gives a good example for you if you still do not understand fully that concept. So contributory negligence and assumption of risk are the two primary defenses that we'll talk about in a negligence context. Moving on to page 254, we come to this notion of negligent as opposed to intentional misstatements. Negligent misrepresentations. It's an incorrect statement that's made carelessly. And that type of negligent misrepresentation could have, obviously, consequences to the person who made it. They give great example, the professional context is the best one. If I, as a lawyer, give bad advice unintentionally, carelessly, to somebody else, and they follow that advice, and there's a harm as a result of that, then I could be held liable for professional malpractice. That misstatement that was reasonably relied upon by the client could be responsible for my insurance company paying out money for damages for the harm that was caused to my former client. No, that's never happened to me. But it certainly has happened to a lot of lawyers. So this notion of a negligent, careless misstatement is something that falls, of course, within this field, this realm of negligence. Page 255, the same rule applies when it comes down to the issue of products liability. Okay? If there's something that's defective, if there's food that you eat that happens to be infected with something, it comes down to consumer products liability that's generally protected, not just under a traditional theory of tort, but also oftentimes we have particular written laws that are designed to protect you from the harm that occurs because of the negligence of the manufacturer. If we go on to page 258, we come down to the final concept, and again, we're just touching on stuff, guys. We come down to that final concept that I mentioned early on. We have intentional torts, we have negligence torts, and then we have something called strict liability. And this is perhaps the only part of this text that'll touch on strict liability. It's the principle that liability is going to be imposed regardless of proof of negligence. Just by virtue. It doesn't make a difference if it's careless. It doesn't make a difference if it's intentional. The bottom line is the law says that you're going to be held liable one way or the other. It's strict. If they prove that it occurred, then you will be held liable. Period. Negligence doesn't make a difference. You don't have to jump through all the hoops with the four characteristics, the four factors of negligence that I discussed before. And they give a couple of good examples here. They talk about liability for fires, for dangerous animals, and for the escaping of dangerous substances. If you pour toxic waste, or if toxic waste leaks from something that you own onto the ground, you will be held strictly liable. If your dog or if your snake gets loose and bites somebody else, you will be held strictly liable. If you inadvertently on a camping trip fail to put out your fire properly, your campfire, and it causes a blaze, you will be held strictly liable. Society relies upon us to punish things strictly so as to deter, so as to prevent other people from ever doing it, whether it's again or initially. They talk about, although strict liability makes rare appearances in torts, it would be wrong to conclude that businesses rarely face strict liability. And there is strict liability in contract, as well as we discussed in Chapter 10, vicarious liability, this notion of respondeat superior, involving the strict liability of an employer for the actions of an employee. So there is this notion of strict liability that crosses over into these other concepts. Now, that's it for Chapter 11. Please review Business Law and Practice Revisited, we get back to the initial hypothetical from the beginning of the chapter involving the meat company. Please review that carefully on page 259, 260. It will only enhance your understanding of the concepts discussed in this chapter. You may think it's dry, all right, but you know what? Once you get accustomed to reviewing it, you actually find it, I think most people find it interesting. Plus, it's valuable to you guys. You have to understanding negligence law will help you understand both in your private and in your professional life how you can conduct yourself to try to minimize being confronted with a case of negligence. I mean, I think about it all the time. I think about it when I walk into a grocery store, whether it's a Pete's or whether it's a Superstore or whether it's a Sobeys or some other chain. I think about exactly what happens on the ground, and if I see a bit of a spill, I think about those things. Those things concern me. Everything that I do in life is based around the fact that we can't protect ourselves against every possible action. I would have to argue that at some point in our existence, each and every one of us is going to be careless in some way, and hopefully to the point where it never actually impacts another individual. But again, understanding what negligence is about, understanding the standards, especially if you're going to be in business, is critical. So please read over chapter 11 very carefully.